frequent report on behalf of the NABARD has been placed on record. Prima facie, certain allegations were stated to be true.
But that is prima facie. Subsequently, NABARD files an affidavit and says that we have now looked at it and there's nothing.
Later,
Anyway, as a PIL petitioner, your duty was to point it out to the High Court. High Court went into it. NABARD is a national bank for rural development. They file an affidavit. Now, why should we?
But the error is page 389 may be seen. Uttar Bihar Gramin Bank, as well as the sponsored bank, Central Bank of India, was directed to take decision on this erroneous activity. But that is my.
But look, ultimately, as a bank, it is regulated by the state authorities, since it's a state bank, as well as to a certain extent by the Reserve Bank of India. Why should we presume that they will not look into the any regulatory failures in the bank?
Not any fraud above 3 crores is directed to be investigated by CBI. But here the quantum is not above more than 500 crores. That is.
Sir Counsel, we are referring to the affidavit filed by NABARD dated 21st February 2024, where the averment is that it is humbly submitted that as per the specific directions dated 18 January 2024 of this court, the instances pointed out in the special audit report were scrutinized. On scrutiny, respondent number 4 is satisfied with the resolution of the board of UBGB that the guidelines of fraud are not applicable to the present matter, audit report, and therefore the matter is not required to be referred to local police / CBI as per clause 9.1 and 9.2 of respondent number 4.
Initially, 13.
I think we made our point clear. I think we'll not entertain it further. It is a PIL after all. Yes, dismissed. Item 6.
Okay.
Item 6. Yes, Mr. Raghunath, you are on the screen.
Advocate Raghunath on behalf of
India. Filed a writ petition before the High Court for early hearing of your appeal before the DRAT. And now you are in the Supreme Court under 136. We're not going to entertain these kind of...
Your Honor, my Lord, these steps will be against the order of the Honorable High Court, and there is no supervisor. There is no... about 24 hearings have happened.
What do we do? The tribunals are... It's not that the tribunals don't have work. They have their own priority.
But my Lord, it's a question of recovery of 208 crore rupees.
I know, but you are postulating that your case is the most important to be reaching the line or the queue. Other cases may be as important before the tribunal. Why should we expedite your case? We'll not do anything like that. Thank you. Dismissed.
This is a petition seeking appointment of an arbitrator. The clause of arbitration which finds place in the SPA was SHA, which was initially disputed by the other side, gradually accepted on an affidavit and recorded by the High Court in its order, saying that they were trying to mislead the court, but they've then accepted the existence of the SHA and the arbitration clause. We had only seeking appointment of an arbitrator because one of the respondents is a Sri Lankan citizen and the other is an Indian citizen, both of them being shareholders in the company, which was created pursuant to the SHA.
My lords, I'm appearing for the respondents herein. Let them supply me a copy. I'll come back in 2 weeks and give my no objection for the appointment.
For the appointment of the arbitrator?
Yes, my lords, after perusing the agreement, because there was a confusion about the agreement per se, the notice of invocation says the arbitrator.
Fair enough. You're appearing for both the respondents, right? You're appearing for both the respondents.
Yes.
Fair enough.
No, they have admitted the existence of the...
He doesn't have a copy of the papers. He's on caveat. So
I'm not on caveat also. I'm just appearing.
Issue notice. Mr. Can I have your name?
Karthik Malhotra.
Mr. Karthik Malhotra, then counsel appearing on behalf of the states that he has instructions to appear on behalf of the respondents and seeks a short adjournment to take instructions. A copy of the paper book be supplied in the electronic form to the Senate Counsel for the respondents. List on. Should we keep it on Monday and finish it on Monday?
Please, my lords.
My lords, Friday.
All right, next Friday.
Next Friday.
Very good. Next.
Yeah. Item number 8.
8, my lords.
The candidate who was selected as the president of the Consumer Disputes Redressal Commission for Mallarkotla,
Sangrur.
for Sangrur. The candidate who was selected resigned
Within 6 months.
within 6 months, in which case you are the second candidate. You have no vested right for appointment.
Normal.
If the candidate does not accept the appointment, then the second candidate can say that, well, appoint me to the post.
There's only
Once a candidate is appointed, then the select list comes to an end because the process is
Our
complete.
submission was only this, my lord, that the OM says that if a person joins and resigns or vacates within 1 year, then, my lord, the merit list has to follow. In this case, my lord, the OM is there and the judgment of my lordship, 3 judges of this court have said. And my lords, this is since no, that's right, my lord. But my contention is that since this is a judicial selection, instead of going through a fresh selection process, my lord, people can, and I'm there in the merit, my lords.
The government picked out all candidates who are lower in the list. That whole selection process in Punjab was replete with all kinds of
What they have
difficulties.
done is, in my district, Sangrur, after, my lord.
Because the Punjab government thought that they can just pick up candidates who, are, suitable to them, overlooking the select list.
So that's my case. When one resigned, they appointed someone who was not even in the list, who didn't even apply. I was there at number 2. They didn't call me.
His appointment may be invalid, but
So
he has no vested right.
So here, he's R5, my lords. He's R5 here. I said so in my LPA. When the writ was pending before the Honorable Single Judge,
Whom did they appoint?
they appointed one Jyot Karan, who was not even in the select list.
No,
Page
but look at
70 is the select list.
But look at it this way.
Yes, ma'am.
Your plea was appoint you. You're not really concerned about his appointment.
In the writ petition, it was appoint me. When the judgment is reserved in the writ petition, on that day, they appoint this person. I filed an LPA. I said, how can you appoint him? You have to appoint me. The OM is there in my favor. The 3 judges is in my favor.
Did you ever challenge his appointment?
In the LPA. Because in the writ petition, he was not appointed. He was appointed on the day when the judgment in the writ petition was reserved. So I could not have made him a party in the writ petition. I made him immediately in the LPA. I made him immediately in the LPA. I made an application, and he's R5 here before your lordships. A person who is not selected is working, my lord, as a presiding officer of the Consumer Forum, and I was there in the merit list. And the wait panel. OM says, my lords, the panel.
Petitioner, the grievance of the petitioner is that the candidate who was first in the select list, right?
Very well.
The candidate who was first in the select list for appointment to the post of president of the Consumer Disputes Redressal Commission, Sangrur, resigned. Full stop. Thereafter, full stop. The petitioner was second in the select list. Full stop. According to the learned counsel, after the judgment was reserved by the single judge,
yes,
and before it was delivered,
yes,
the 5th respondent was appointed as the president of the District Consumer Disputes Redressal Forum, though he was lower.
He was not in
though he was not in the merit list at all. Full stop. The petitioner has been non-suited on the ground that once the first candidate, was it a fresh appointment then? They just picked him up without
him.
All right, we have recorded your submission. The grievance of the petitioner, therefore, is that even if he was not eligible to be appointed as the grievance of the petitioner is that the selection of the 5th respondent is completely contrary to law, since his name did not figure in the merit list at all. Full stop. Issue notice returnable on after 2 weeks. Dusty permitted in addition. Liberty to serve the standing counsel for the state of Punjab in addition. You have come here after 280 days delay.
Father,
Dismissed it on
Father
20.
passed away during this period. Father was very serious.
280 days is too.
280 days.
And on interest, claim is on interest in addition to the return of compensation.
I invite your lordship's kind attention, but page 19 only. Page 19, just, it has been recognized. It has
What's
been
the point?
approved. Yes.
What's the point that you want to make?
Well, it has been approved. It has been said that yes, this due is there.
You have to open that, to open the door, you have to first get the delay condoned.
My father passed away. I've said so. And he was bedridden, and
There's a delay of 280 days in filing the special petition, for which there's no satisfactory explanation. Full stop. The petition is dismissed on the ground of limitation.
I circulated a note yesterday evening.
Yes.
My point is that it's a statutory violation. I'll be rendered remedy.
Tell us one thing,
Well-
after the conciliation proceedings failed
Yeah.
before the facilitation council, you have said that they never called upon you to file a statement of claim. Is
No
that
statement
correct?
I was a defendant, so no statement of claim is filed, no evidence, nothing. Just that the initial claim form which is filed before the MSME, which is a unreasoned, just one page of form. On that basis, only the ultimate order
And
is
did you
passed.
get to file your statement of defense?
We did get to file those. We got to file those. But the conciliation, how it failed was that the first day I show up without the wakalatnama, that day itself, the other side prefers an application, already pre-drafted application. And on that basis of the application, same day, immediately the order is passed, there's no conciliation possible, let's move. But section 65 of the Arbitration Conciliation Act says, mandatorily, both sides have to be called upon to file the written responses, and that concession has to happen in good faith. Even UK law and all, they have gone into that level where they say that
Right.
good faith.
Assuming that conciliation failed, thereafter what happened before the?
No conciliation happened. Then I was called upon to file my defense. I filed. Then arguments reserved. Some fellow, Mr. RK, heard the arguments. The ultimate award is passed by some other 3 people who have not even heard the matter. So RK is the signatures on
You have come here against which order?
Well, I've come again the order passed by the division bench of the High Court saying my 34 is not maintainable. 34 I should have gone in 34. Writ petition is not maintainable.
But you have a remedy under 34, right?
Well, I won't have a remedy under 34 because section 65 violations of the Arbitration Conciliation Act are not palatable under 34 grounds.
No, but there's
So-
what you are aggrieved by finally is the award.
Well, I've tried to draw a distinction from that India Glycos judgment, which is falling from my lord. I'm conscious of that. There's a Jharkhand Urja judgment in my favor, which says if the mandatory statutory violations have taken place, then writ petition is maintainable vis-a-vis the MSME Act. Squarely covers my case. Number 2, my lords, the India Glycos judgment and other judgments which my lords have held, those are cases where people were trying to make their cases on merits of the case. I am not on merits at all. I am on the violations of the MSME Act. And I am trying to portray my case there, my lords. So my humble submission is basic structure 226, etc., will be attracted when statutory violations have taken place. If it was a case on in fact,
Problem is that you are yourself saying that you're not challenging it on merits, but only on statutory violations.
the merits grounds are also there. I'm saying for the
point on
statutory.
merits which you raised was that that they were not registered as a micro MSME on the date of the agreement.
No,
To which there's a finding of fact concurrently that they were registered.
no, what has happened is those merits arguments are also there. But to distinguish my case from the previous judgments,
For
that's why I'm
sale of-
trying to portray my cases
for
there.
goods sold, supplied and delivered. You have not paid them.
No, my lords, that's not the case at all. My lords.
Yeah,
The
that's-
case, my statement of defense is not on record. My apologies on that. But what if the transaction is slightly different?
Balance of the principal amount of 24.82 lakhs was not paid.
Because I'm ready to deposit the principal amount. That's no difficulty at all. But the point is, my lords, my defense could not be brought on record because there's no procedure that has happened. There's no basic arbitration and conciliation norms that have been followed. In fact, my lords, there's one Delhi High Court judgment which says if it shocks the conscience of the judge, then the writ petition is maintainable, even against MSME matters.
In a petition under section 34, all these grounds, suppose in an arbitration, forget the MSME Act, arbitrator doesn't hear the defendant and passes an award. Is that not amenable to a 34 application?
I bought on my lords. The mandatory provisions of Arbitration Act not followed, ground under 34, absolutely correct, my lords. But my lords, this is under the conciliation process of section 65 violations. So they may not be followed under the 34, my lords.
Conciliation.
And besides, my lord, one person hearing the matter, other person passing the award, who I don't even know.
But why did you not choose to challenge the award under section 34?
My lord,
All these grounds are available. That's your ground is a violation of public policy.
my lords, my lords, I'm only saying, my lords, that under the Jharkhand Urja matter, I'm squarely covered, my lords.
Thereafter, it becomes an executable decree, right?
My lords, may I say this, my lords?
For the writ is that you don't have to deposit.
My lords, may I say this, my lords? The Jharkhand Urja judgment which covers me is of 2021. My lord's judgment is of 2023.
Leave it open to pursue your remedies under section 34.
I'm so grateful, my lords.
The petitioner had an efficacious remedy of challenging the award of the Facilitation Council under the MSME Act by taking recourse to the provisions of section 34(2) of the Arbitration and Conciliation Act 1996. This was the matter, the High Court was justified in declining to entertain the writ petition under Article 226 of the Constitution. Hence, we are of the considered view that the grievances which are sought to be raised in these proceedings can be addressed in a petition under section 34, full stop. Any observations by the High Court on the merits in the impugned order shall not stand in the way of the petitioner taking recourse to the remedies to challenge the arbitral award.
I'll be hit by delay, my lords, because now.
You can say you were bona fide pursuing your remedies before the High Court. What else can we say?
My lords,
We can't condone the delay, which is beyond now the 90 days.
My lords, that's there, my lords, but that will be rendered me, my lords. It's a good case on merits, my lords. My lords have seen what has happened in this case, my lords. In fact, my lords.
We have vested right in yours to their benefit. How can we obviate a limit set by Parliament?
I understand that.
Then really speaking, if it's barred by limitation, you should just dismiss it. Otherwise, your client will spend another round of.
No, my lords, but my lords give me liberty, my lords may not fructify to my interest if the debt delay aspect is not covered.
All right. But we'll not condone the delay here. You have to move.
My lords may only observe that I may permitted to raise these points. That will be, my lords.
You can always say that condone it, but we can't because there's a maximum period which can be which is condonable. We can't go beyond that, like the IBC, the Arbitration Act, etc. Condone the delay of 36 days in filing the SLP. There's no difficulty.
No,
then you can say I was pursuing my remedies bona fide before the Supreme Court.
I'm in my lord's hands, my lords.
Condone.
Item 11.
Question sets aside, my lord, the well-reasoned decree and the judgment of the trial court. Para 15, my lord, it proceeds to record a wrong date, contrary to what has been pleaded by the plaintiff himself. And then my lord says that we were at fault in not pinpointing it promptly. My lord, three things were missing from the impugned judgment. If your lordships may please see, my lord, page 1.
You paid them 90% of the payment.
That's right.
Right?
Right.
So the dispute was only in regard to the balance 10%.
Lordship, please.
So the High Court says first, the very fact that you paid 90% shows that the work was being executed. Now, question is still, I mean, you may still have a point that, there were delays or deficiencies on the part of the respondent. Where did you raise the issue of delays or deficiencies?
No, my lord. We have said so in the written statement, coupled with the fact, my lord, there is a finding of fact that the work completed was only to the extent of 90%. And therefore, my lord, the learned trial court held this, my lord. Please have a look at page 175.
So what evidence did you produce to establish that there were delays?
Yes, yes. 30th of next year, P11, your lordships may see. Or my lord, lordships may please have an next year P12. Now, this letter, which we have pointed out, my lord, on 30th November 2012, the judgment in question says that you...
But tell us what is the evidence which you laid?
My lord, this was one of the letters, my lord, 30th November, and the rejection letters at document P11. Kindly just see, my lord, next year P11 from pages 102.
You had to prove your defense that there were delays and that there were delays or deficiencies by adducing the evidence of a person cognizant of the contract which was being performed, and then establish, by producing documentary material that, well, there was a shortage of work or there was measurement carried out which resulted in,
Lord, if I may say so with respect, my lord, next year P11 pages 102 to 115 were the rejection notes.
Then, my lord, the chairman of the company appeared as DW1. And then, my lord, 30th November 2012 letter, which was within the warranty period, but not considered by the judgment in question, that has been set aside, my lord, on the premise that the work was completed in July 2011. But the plaintiff himself says that it was in 2012. Para 19, if I may just draw your lordship's kind attention, please have a look, my lord, at para 19, page 187. That is, my lord, the fundamental error, my lord, in the judgment. Besides the point, my lord, that para 19.
Ultimately, you are here under 136.
I know, my lord.
That's
But,
the problem.
my lord, only two respectful submissions. First and the foremost, my lord, the evidence, etc., my lord, even the bills which were presented. The learned trial court has held that these were not actually the bills which were submitted or ought to have been submitted. They have not been proved. Then, my lord, there is a heavy discrepancy on my pointing out the deficiencies because the High Court says, my lord.
It's purely a matter of appreciation of evidence in our case for. Thank you.
As right.
This has to be tagged. This has to be tagged. Ganpati deal.
This has to be tagged.
Benami.
But kindly see the tribunal's order for a minute. Page PDF.
You are appearing for?
Well, I am on caveat. I don't know what the.
We've got other matters which are pending, so we'll.
Well, kindly see, because ultimately the tribunal, I had gone an appeal. The tribunal has decided this issue only on Ganpati Deelcom, not on merits. And with the liberty given that if review is allowed by the Supreme Court, please come back.
Therefore, we'll tag it,
So
we'll tag it.
request is because ultimately even my lords tag it.
We've got other matters pending.
No, I'm not saying no. It's not that they are remediless. Tribunal says if the review is allowed, please come back to us. That's liberty.
We'll keep it here.
On merits, ultimately my
We don't want to follow a different course of action because this will affect other matters which are pending. So we should notice and chat.
Lords have dismissed the numerous matters.
We'll keep
before,
it. We'll keep it here. Yes.
Well, ultimately, because my lord will be sending back to the tribunal.
All right.
Right.
My lords, I'm humbly praying for a Passover, my lords.
Tell us what the matter is about. You argue.
My lords, the learned Solicitor General is leading us, my lords.
But for us, you are the Solicitor General at this moment. Tell us what the matter is about.
My lords.
Matters about.
Argue for 5 minutes, then we'll look into.
Mr. Solicitor, just one second. Let your junior argue the matter. Please sit by his side. Yes. Tell us what the matter is about.
My lords, the matter is about non-filing of affidavit of admission denial along with the written statement, my lords.
So the High Court has relied on the Delhi High Court rules.
My lords.
According to which the list of documents has to be filed at a much anterior stage. It says without an affidavit of admission and denial, right? So the written statement, it says, will not be taken on the record without an affidavit of admission and denial.
My lord,
that's the Delhi High Court rule.
That's the Delhi High Court.
That's why you have been non-suited. Now, what is your answer to that?
My lord, CPC Order 11, Rule 4, my lords.
Yes.
It is very clear, my lords. The affidavit of admission denial has to be filed after interrogation and investigation of the documents have been done, my lords.
And what does the Commercial Courts Act say?
Commercial Court Act, my lords. This is the Order 11, Rule 4 as amended by the Commercial Court Act, my lords.
Right, but which is the provision of the Commercial Courts Act?
My lord, the Commercial Court Act amends CPC.
Which is the provision of the Commercial Courts Act which you are relying upon?
Page 15, my lords, of the impugned order.
Solicitor said 15, so you said 15. Hello, we issue notice. Oh, right. Issue notice. We have heard Mr. What's your name?
Avinash Agarwal.
We have heard Mr. Tushar Mehta and Solicitor General with Mr. Avinash Agarwal. Issue notice. Tenable on till so and so further proceedings. Should we stay the proceedings? Further proceedings in the
The real question would be the High Court says
the rules will prevail over the Act, over the CPC.
Para 22.
Returnable on so and so. pending till the next date of listing, there shall be a further, there shall be a stay of further proceedings in the suit. Don't you know, here what happened was that they didn't file. One 23 days will issue notice on bill.
The advocate underwent some ISIS.
Item 14.
But I beg to appear on behalf of the petitioner. My lord, firstly, my lord, the Honorable
The
High
issue
Court.
is as to whether after the appointment of the arbitrator by the Calcutta High Court,
Yes.
the Tripura Commercial Court could have refused to refer the matter to arbitration. And I think the High Court is
My simple answer to that is, my lord,
the High
without,
Court had appointed an arbitrator.
without examining and considering the records that were lying before the arbitrator, which is completely a separate set of pleadings, my lord, before the arbitrator. My claim before the commercial court is completely independent of the dealership
All this
agreement.
can be argued before the arbitrator. Why should we entertain it at this
But
stage?
the Section 11 application on the basis of which the arbitrator has been appointed by the Calcutta High Court, my lord, is
No,
based on arbitration agreement.
The long and short of the story is that it can be sent to the arbitral tribunal. Why should we?
My lord, my set of pleadings in the commercials, it is completely independent of the dealership agreement. I am not at all governed by the dealership agreement. There is a basic misunderstanding on the part of the court, my lord. Secondly, my lord, without considering and examining the records lying before the arbitrator at Calcutta, my lord, the court could not have at paragraph 18, my lord. If your lordship kindly turns to page 15, paragraph 16.
Ultimately, what has the High Court done? The High Court has said that let the commercial remand order and saying that the commercial court should consider this.
Yes. Man, there could be parallel proceedings, man, without looking into what was there before the arbitrator. The set of claims that were completely different, and my claim before the is a money suit, my lord. It's a simple money suit. It's a commercial claim. It is not a case of claim and a counterclaim. My set of facts are completely independent of the dealership agreement. Paragraph 10 of the plaint, my lord, that is a different set of facts. Secondly, my lord, the High Court had interfered with the order.
Who are you actually? Who are you in the sense? Who is your client?
My client is the instant petitioner, my lord, who has filed the commercial court in the Tripura High Court, in the commercial division court in Tripura.
You are the dealer.
Yes.
You are the dealer.
No. Yes, I am a dealer. I am a dealer, but not eminently from.
Maybe you are saying that your claim is independent of the dealership agreement.
Yes.
Your status arises as a dealer under the dealership agreement.
No, that dealership
agreement says, please consider our order. It directs the commercial court to consider their order, appointing an arbitrator.
Yes. Well, the arbitration agreement, which is between me and the dealer, maybe, my lord, it's an alleged document, is not at all a document which is with my custody. I have specifically stated in my plaint that I have never seen, this document has never seen the light of the day. In that event of the matter, my set of pleadings in the commercial court could have been in the light of the dealership agreement.
All this,
but
this has to be looked at by the arbitrator. All this
arbitrator is deciding on the dealership agreement. That is for the respondent. That is that is the claim of the respondent against me. My claim against the respondent is completely different, and my suit is a prior.
You heard your point. No, it has to be before the arbitral tribunal. But anyway, we are not directing it has to be sent to the arbitral tribunal. The High Court has merely remanded the matter, directing the Tripura Commercial Court to consider its order, Calcutta High Court order, appointing an arbitrator. That's all.
But my lord, this is where I join my issue, my lord. Just one way.
I heard you now. I think we've made access clear.
To say, my lord, that the Calcutta.
In item 15, it is in my humble submission that the Honorable High Court has committed grave error in saying that the minor dispute was transferred to respondent number 1 because it was transferred without following the provisions of law, and according to me,
but
it is
before
void.
That, you have to answer why we should condone the delay of 170 days in filing the SLP.
My Lordship, because the petitioner was not knowing that there is a limitation in filing the SLP in the Supreme Court, and the advocate who was dealing with the matter in High Court
was on the ground of delay. Yes, thank you. Item 16.
My Lordship, may kindly consider as soon as we got the matter, we got it filed. My Lordship, may kindly consider, because the petitioners are also very not very poor. My Lordship,
they have been in possession of the mine for the last 50 years.
But my lordship, that transfer was illegal, my lordship. That was not.
Not a case for injunction, the High Court says, that somebody who's in possession of a mine for 50 years, they can't be now injuncted like this. So if though we are dismissing, we can say this, we can even say this, though there's a delay of 170 days in filing the special petition, we have also examined the correctness of the impugned order on merits and find no reason to interfere with the order. The special petition is accordingly dismissed, both on the ground of delay and on merits.
My lordship, one
That's
last.
better, so that item 16.
Blacklisted issuing any show cause notice and contrary to the terms of the tender itself, if my draw your lordship's attention to page 98.
The cancellation maybe. Learned Senior Counsel appearing on behalf of the petitioner submits that the petitioner was blacklisted for a period of 3 years from participating in the works of in the contracts of the municipal corporation without a notice to show cause being issued. Issue notice confined to the above aspect.
Lordship.
Returnable on.
Lord, we are only requesting for a stay, Lord, because I won't be in a position to participate in any of the options, my Lord.
We'll make a short note.
Lordship.
Oh, I see.
Lordship.
It's a due process.
Obliged.
17 number of petitions have been disposed of by the High Court. All the matters are not listed today. They pray for a one time.
But there's a 174 delay, 174-day delay here.
No, as far as the first matter is concerned, there is 74.
174-day delay.
In other matters, it is not there, madam. In other
174.
Yes, but in other matters, the delay is not too much, madam. Kindly see, madam. In some matters,
17. How many matters are there on 17?
In total, there are 8 matters, 7 matters, madam. All the matters are not distributed, madam. It will be taken after a week, madam.
You can get your other matters. We'll dismiss this on the ground of delay.
No, kindly see, my lord.
How can the state keep on saying that, look, there are other matters where there is no delay, therefore condone?
I'm not saying, I'm not saying, madam. Kindly take up all the matters together, because as far delay part is concerned.
We will keep those other matters. We'll dismiss this on limitation.
Madam, kindly take up this.
Limitation applies equally to everybody, and I think state governments in India now must be absolutely alert. And merely because it is a state, the government officers cannot just sit
as per my
and allow.
74, my lord.
And it's serial number 37, there's 74 days delay. We'll look at that matter independently. When it reaches, we'll take it up. This one we will dismiss on the ground of limitation.
No, my lord, I'm just saying that we'll take, because on the technical ground, kindly see, my lord. Technical ground, my lord, they have to more than 3 or 4 crore rupees, my lord, kindly see. They have to pay more than 3 or 4 crore rupees, my lord, kindly see.
7 reaches. We'll see what the merits.
All the matters are not listed today, madam. If I'm saying, if you've taken after a week, madam, all the matters, madam.
How many are there?
In total, there are 8 matters, madam. Only 3 or.
Like, give the number to the numbers.
Yes, I will give the numbers, madam.
List together with so and so.
On Friday, madam, next Friday. In the meantime, if there is defect, I will give the defect all them.
Item 18.
But it's on Friday, madam?
Next Friday.
Very clear.
This is a really piquant and unjust situation where I can't appoint an arbitrator. The matter is under litigation. Their appeal has been remanded by this honorable court to the High Court because it was earlier dismissed as non-maintainable. So the arbitration award has been set aside as being perverse at my instance.
The arbitration award was set aside by the single judge.
Section 34 judge?
I think Justice Dhanuka's judgment.
That's right.
We had dealt with this.
Justice Baldota's judgment.
Justice Baldota's judgment. There was a similar case which just came a few days back where there was the division bench set aside Justice Baldota's award on the
ground of perversity.
On the ground. What happened in the single judge?
No, thereafter, after the award was set aside on the ground of perversity, they filed a Section 37 application, which was dismissed as non-maintainable. Then they came to this honorable court. This honorable court found the appeal was maintainable and therefore remanded it back
to the division bench.
To the division bench, and that matter is still pending, though we have made requests, and this honorable court had also directed expedition. That matter is still pending. When therefore this matter is still pending litigation, And the situation is that a perverse award against me has been set aside behind my back. 2018, they enter into a development agreement with respondent number 3. This is not disclosed. It is disclosed for the first time in 2023, where when I discover by chance that a huge construction is being put up, I move an application.
Mr. Ramchandran, what is the investment by your client?
The investment by my clients is 22 lakhs in a matter of 1.5 crore at that time. The amount should not matter at all, my lords. That was the initial payment.
You know, if a construction has taken place, and now you have invested about 22 lakhs,
he has paid 8 lakhs, my lords. The respondent number 3 has paid 8 lakhs. It can't go by the figures.
Seems to have also been impressed by the fact that now impeding the development, the tenants on the property who are waiting for being rehabilitated.
With respect, my lords, with respect, those tenants who are part of the original bungalow, it's not some resettlement scheme. It is a bungalow which is being demolished and a 15-story structure is being put up.
The award against you in the arbitration, right? The award in the arbitration. What is the actual award in the arbitration which was set aside?
The award was that I'm not entitled to specific performance and I'm not entitled to damages, both of which have been set aside because the award has been held to be perverse. So the matter is at large, and I file a fresh Section 11 application for the reason now that this third party has come. This third party seeks to get impleaded in that appeal. And I can't appoint a Section 11. Award was that my claim was dismissed. My claim was against his reneging on the 2005.
So your claim
MOU
for essentially for specific performance or implementation of the MOU, that was rejected by the arbitrator. The single judge set aside the award and just set aside the award simpliciter.
Simpliciter on the ground of perversity, but set it aside.
Right.
Therefore, fresh arbitration has to start. In any case, a fresh arbitration has to start. Immediately after the appeal was dismissed by the Bombay High Court, I filed a Section 11 application for fresh appointment of an arbitrator.
The appeal is by the other side, of course.
The appeal by the other side. When that appeal was dismissed, I filed a Section 11 application. But then this honorable court remanded the matter back to the High Court. So logically,
even assuming that ultimately in the appeal, the award is affirmed, you still have recourse to a fresh Section 11.
And that is not being allowed by the impugned judgment. That is what is not being allowed.
They have created third-party rights in the meantime.
Lordships, and they have created third-party rights. And well, a fault is being found with me.
We'll have to consider this because you have been non-suited even on your
Lordship, please.
Section 9 or something, we may or may not be with you.
Section 9 minutes, my request is this. If behind my back, this agreement is entered into and not disclosed to the court,
You're also a very big builder in Mumbai.
Lordship, please.
There's nothing behind your back. You see the whole construction coming up, and you said a big building is
I
coming back.
happen
Nothing
to,
is behind
I
your
happen to
back.
see it because I was passing that way. I was passing that way. I'm not traveling on all the roads of Bombay every day, Milords. I'm not traveling on all the roads of Bombay.
This is not by this.
On section 9, Milords, if your lordships are issuing notice.
11, perhaps you have a point that at least your remedy under 11 can be kept open. Depending upon the outcome of that appeal. Perhaps we'll see.
On section 9, my only limited prayer is this, Milords, as your lordships issue notice, let them not create third-party rights in favor of buyers. Let them not.
We are issuing notice. We'll make a short notice. We don't want to issue an interim order without hearing them. Serve dusty and come. We'll just rise, members of the bar will rise because our distinguished colleagues from Brazil have to go around the court and look at the facility. We just rise for 2 minutes. And
before the learned visitor, Milords, rises with your lordships, I thought an anecdote, seeing your lordships encouraging a junior a few matters back. 48 years ago, Milords, in court number 2, Senior Justice Chandrachud was the presiding judge, and a 2-month-old lawyer, namely yours truly, was appearing before him, shaking with nervousness. And Senior Justice Chandrachud looked at the appearance slip and said, "Yes, Mr. Ramachandran," which gave me such confidence that I was able to argue a useless matter for 5 or 10 minutes. So I was reminded of that day, Milords, when your lordship.
Thank you, Mr. Ramachandran.
But can I request, Milords, for dusty in addition, Milords, so that it comes in 2 weeks, Milords?
I just told the court master it will be served dusty and after 2 weeks.
And no third-party rights, Milords, in the meantime.
That's why we are giving you 2 weeks. Thank you.
Lordship, please.
Parmeshwar, which are the states which have not implemented our judgment?
I just circulated a note here. I have a note, Milords. I have a detailed note in this.
You have the note here?
Yes. What is this kindly take the note?
Mr. Solicitor, that is the updated position you have now of who has...
Yes, I have the updated position till yesterday night.
Then it's
Till yesterday night, we were served affidavits and compliance.
By the way, copy is.
But I just wanted to bring to your lordship notice, this is the 6th or 7th time your lordships are asking them to pay up allowances and pay ballots. If your lordships kindly see the major defaulters, let me just point out from page 6 onwards. Well, that's a number of high courts have deducted TDS on allowances, my lord. So that issue I'll come to. But if your lordships...
Because allowances, you can't deduct TDS.
It is at all protected under section 192 and section 1014 of the Income Tax Act completely, because it is for money spent that allowances are paid. So there's no question of TDS, but I'll come to that a little later. If your lordships kindly see from page 6, Allahabad. 6 minutes. So Lordship sees, so far as Allahabad is concerned, my lords, there is more or less compliance. I shouldn't take, I think there are minor difficulties which will get ironed out, my lords. So far as Andhra Pradesh is concerned, there is substantial non-compliance. I've marked
Substantial?
it in non-compliance. Your Lordship sees the last two columns. So far as payment of revised allowances are concerned and payment of arrears of allowances, my lords, most judicial officers have not received it. Most judicial officers haven't received.
Fixed, my lords, may just for payment of arrears.
Possibly, I just wanted to bring to your lordship's attention. The 7th time your lordships are extending time. Repeatedly, your lordship, I've recounted all those orders in the first 3 parts of my notice. At best, my lords, August 15. There are states which have moved IAS asking for 6 months, 2 years. Orissa on its own.
15th August.
15th August. All states, my lords.
A note has been submitted by Mr. K. Parmeshwar, then the mic is curate, indicating the status of compliance with the orders passed by this court on.
My lords, 3 orders, my lords, 27/7/2022.
27 July 2022 to July 2000.